called for, and for some reason I printed, but I didn't bring, I guess, grab out the Carmine agenda. Do we have anything besides just the consideration? Okay, I thought this was it. So this is the consideration of the report and recommendations from the estimable Oregon State Capital Work Group Harassment Work Group. I was in the Legislative Administration Committee last week when Commissioner Runkles-Pearson presented this in the draft report to the committee. Our task today is to consider the final report. There was one additional work group after the presentation of the draft report. So we have now the final report and recommendations, and our task today is to hear the presentation of that from PK and then consider the adoption of the report and recommendations to submit to the legislative leadership that requested the work. So with that, PK, I guess I'll turn it over to you and ask you to walk the commission through at a high level as an introduction to the consideration.
Thank you, Mr. Chair. Happy to do that. So thank you to all of the commissioners for meeting so close to the holiday. We, as you know, a few months ago, it seems like yesterday, but it was probably 6 or 7 months ago when we accepted this work. We knew it was going to be a very tight time frame, and indeed it has. We've needed basically every second, and in the final months, we were meeting every 2 weeks for several hours and then having subcommittee meetings in between. So this has been a tremendous amount of work in a short period of time, and we appreciate your meeting with us so that we can get this to the legislature on time before the start of the legislative session. As you may remember, this work came to us as a referral from the leadership of the legislature, asking us to provide input on best practices, potential policy, statutory, and constitutional changes to help them address workplace harassment. It just so happened that this particular project fit very neatly within my own area of expertise. I'm a partner at Miller Nash Graham & Dunn, where I specialize not only in employment and education work, which touches on harassment frequently, but also on constitutional law, and this project had all of those dimensions. We were able to put together a work group that I really thought of as a super group. I did not expect all the people that I asked to say yes, and they did, and I was tremendously pleased. I'm so grateful for their professionalism and their dedication, giving such a great chunk of their time on such short notice. Our group was diverse in both experience and in expertise. It included employment lawyers representing management and employees, 2 former legislators, that would be Representative Berger, who's on the phone, thank you, Representative Berger, and Representative Beyer, and then legislative staff, registered lobbyists. Justice Jack Landau joined us. We had an academic in the field of implicit bias from the University of Oregon, and then we had other professionals with a great deal of experience, both preventing and responding to and investigating harassment in professional and educational settings. Our group was also diverse in how we experienced the world. We were diverse in gender and sexual orientation, in age, and in race. Which was important, I thought, particularly for this project, since we were asked to tackle not just sexual harassment, but workplace harassment in general, which could include harassment on the basis of many other protected characteristics. For this project, we made pretty intense efforts at public involvement. We widely publicized the need for feedback. We provided avenues for people to submit both identified written testimony and also anonymous testimony comments throughout. We took public testimony at the outset of our project, and then once we had draft recommendations. And one thing about this project that I thought was particularly remarkable was the level of transparency. We worked with a working document for our draft recommendations that we debated and disseminated in real time. So after every meeting, we would update where the status of our recommendations were, and we would put them out on the website. And if you've seen the website, Sandy's done a terrific job of making sure that all those materials, including videos of meetings and all the public comment, everything is publicly available. So what did we learn? I think if there's one takeaway from this project, it's that we believe that the most important thing for the legislature to address is culture. And that's because the Capitol is a particularly complex place. As we know, it's a workplace, but it's also a place of public accommodation, a place where people need to meet and assemble and petition their government, and it really is the heart of our democracy. And that means that power relationships in the legislative environment are particularly fraught, and because harassment is related directly to power, this made this environment particularly difficult. Power relationships here are more intense, they're more explicitly, overtly power-based, they're more complex and multifaceted. At any moment, either a legislator or a staff person or a lobbyist or a member of the public, maybe the person in the position of power or the person not in the position of power. And so these positions of power are constantly buried and decentralized. These enhanced power relationships make it difficult for anybody to make waves, and that's anyone, but for this project, what was important to us was that victims of harassment have a particularly difficult time making waves, and so do people who observe harassment. So the testimony that we took and the experience of the work group members who know this environment described a culture that's in need of repair, as are many workplaces and public accommodations in our society, and especially in these changing times. We studied a very complex legal and policy overlay. We studied employment policy, state and federal employment laws that apply, state privilege and public records laws, state constitutional provisions that govern legislative self-government and the right of the assembly to punish its members, we consider the right of constituents to be represented, and we considered all the state and federal constitutional civil rights and liberties like free speech and due process that might be implicated here. Our goal was threefold: to provide recommendations that would stop harassment, that would provide due process and a fair hearing for respondents, and also, in this environment, prevent weaponization of complaints for political purposes. And what astounded me about our process is that even though we had such a diverse group of stakeholders, the recommendations, in all but one respect, which we'll talk about, were completely unanimous about what needed to be done. So as I mentioned, our most important takeaway was culture. The culture needs to change. So how do we do that? One of our main recommendations is that the legislature establish an equity office that has a dedicated and sustained presence in the building, that's working to train and advise, and where necessary, working to remediate harassment. This office would be independent and report to a bipartisan committee. We discussed having an equity office that was somewhere else, that was not under the control of the legislature. We opted not to do that because we thought it would make it more difficult for an outside group to come in and actually understand the culture and work with the culture. There was a fairly sustained split in the group at the beginning, yet we resolved that by making the recommendation that particularly fraught, politically oriented investigations, such as investigations of legislators, should actually be performed by an outside investigator. We focused a lot on the need for training. We had a special subcommittee on training. Our ultimate recommendation is that training should be required for everybody in this environment, including lobbyists. So it's not just staff and employees or legislators. We also talked about not just that training was necessary, but what training was necessary. A lot of training is fairly outdated and just spends a lot of time telling people what they should not do. And where we are in society, most people kind of understand that they should not be doing those things. What they don't know is what they should do. And so training by the more advanced methods that we're recommending include a positive approach, giving examples of how to interact with folks who may be different from you, training folks who are getting this training in bystander intervention, how to interrupt harassment when you see that it's happening, to demonstrate the human impact of harassment on individual people, and then also, and this was a topic of some conversation, addressing generational issues. In this environment, we're dealing with folks from many different generations, and understandings of what's harassing and not harassing change. And since harassment law tells you that you need to look at harassment in large part from the perspective of the person being harassed, it's really important that we understand how folks who are different than us or from a different generation might perceive different behaviors. We talked a lot about the importance of confidentiality and encouraging victims to come forward. We recommend that half of the training office, half is focused on training and not investigations, be empowered to receive confidential reports. We struggled a little bit with how to make those reports confidential, and ultimately determined that unless federal law changes, we are not able to make those reports completely confidential because the federal law of evidence doesn't have to recognize state law. Nonetheless, we recommended that the legislature consider adopting a privilege statute to change the laws of evidence to make these kinds of reports confidential. There exists a precedent for that already. There's already part of ORS Chapter 40 that governs reporting in academic settings to folks who are resources for people who have been the victims of sexual abuse. We recommend that the legislature have a leadership team that's comprised of folks who are actually in leadership, not just folks who consider this to be a hobby but may or may not, or even an important thing, but who may not have a particular level of power. We considered that changing culture requires buy-in from the highest levels of power, and that means that our equity team needs to involve people from those highest levels of power. We've suggested we give the legislature specific direction about interns. Currently, there is no system that is actually followed in the building for determining who's in the building in terms of interns and volunteers. And so there are a lot of folks who just kind of come in the building and leave and never get any training. And so we thought it was important to institute that everybody at least has to register with HR if they're in the building and receive training. And then we think that the training half of this culture office should do an annual culture survey to see what training is working, what training is not working, where it can be improved. So that's one half of the equity office we recommend. The other half, which will be separated from the training side in terms of the confidential reports, so the second half will not receive confidential reports, will be staffed with at least one dedicated and available professional to investigate formal complaints of harassment. And most of the investigations we envision would stay in-house, but as I mentioned earlier, those with a more exaggerated power dynamic would be farmed out to a small and well-vetted group of outside investigators. So all of that we just talked about has to do with changing culture. And we also talked about how to change the policies to address harassment moving forward. We recommended a more robust definition of harassment and retaliation that has real examples that explains to people what behavior we're talking about. The employment lawyers in the group and our member from the Bureau of Labor and Industries came up with that. That's the first appendix in the report before you. We also required or would require a more robust reporting process, as I mentioned, that would have a confidential arm and a non-confidential arm. One dramatic recommendation is that we would expand the coverage. The current personnel rule, which is Rule 27, only addresses legislators and direct employees of the institution. It doesn't address what happens when someone who's from the outside engages in or experiences harassment. So there's whole groups of people in this building that are not covered by the policy at all. We think that the policy should be expanded to cover all of those groups. We also noted, as we did a survey of outside legislators and legislatures and the United States government, that is a national trend. We are seeing more of an expansion to cover all groups that are in the building, regardless of what their formal affiliation is. We also discussed having a longer period within which the legislature would take reports. The current rule only allows complaints to be made within a year from when the harassment has occurred. We split on exactly how long that should be, and we'll talk about that more as we move forward. We decided, while we were expanding coverage, on the one hand, we were still very concerned about political weaponization, and so to balance those things, we would recommend that the complaints be made under penalty of perjury. Some folks were concerned that this would chill and deter complaints, but we felt better about that after discussing that perjury means that you must knowingly lie about something, not that you make a report and then it turns out not to have the evidence to support it. And we think that distinction should be covered in the training so that people will still feel empowered to come forward. There is a prohibition in the current policy stopping people from discussing investigations if they are a witness or if they are a complainant. We thought that ran afoul of established law that allows employees to communicate about the terms and conditions of their employment. So we recommend that be removed. We also recommended that Rule 27 provision that allows HR or a legislative counsel to review the findings of an investigator and request corrections. We would remove that as well. That seems to impinge on the integrity and independence of the investigation. We recommend that there be provisions for interim safety measures. Applicable employment law requires that once an employer is on notice that harassment may be occurring, that's when the employer's obligation to stop that harassment accrues, whether or not they're still investigating whether that harassment actually happened. And so what that means is that an employer does have an obligation to put in place something to sort of make sure that harassment isn't happening during the course of the investigation. And that would be these interim safety measures. We've recommended procedures by which those could be put in place. We also would expand the remedies in Rule 27 that would respond to findings of harassment. Currently, findings against legislators are very limited to censure, reprimand, that sort of thing. We think that there are actually probably a much broader range of remedies that could be possible, and we wanted to open that up. We also would expand remedies to lobbyists and third parties who use the building. These remedies would include fines, might also, in the lobbyist instance in particular, include informing their employers of the finding. We recognize that there were some concerns brought up that some of the punitive measures that could be taken against lobbyists could impinge on free speech. In our view, the recommendations are facially constitutional, but the report does caution that in implementing them, the legislature should be very careful with how they are applied. The alternative to not having these things is basically giving free rein to harass the people in the building, and so we need to balance those interests. We envision that what will most likely happen is that it'd be very rare that someone would actually be banned from the building, that there might be specific restrictions or that there might be fines, but that it would be quite unusual. And that in the context of legislators, we noted that it would be very difficult to impose a restriction that would ban a legislator from casting a vote. That would be a measure that would remove the right to be represented as that legislator's constituents. We also provided recommendations for providing more transparency to a complainant and to a respondent about the timelines in the investigation. And we tried very hard to strike a thoughtful balance between privacy during the investigation and then public disclosure of the fact that the investigation is occurring and the results of the investigation, balancing the need for investigation integrity and personal privacy with the public need to know what's going on in the building. And we also tried to strike a thoughtful balance between an investigation being prompt and an investigation being thorough. We got some criticism from some of our commenters that the timelines we listed were too long. Nonetheless, for those of us who have been involved in actually doing investigations and more complex ones in particular, sometimes you really need 2 months, 3 months to get it right. Not all of those will take that long, but some of them will. We also talked about the mechanisms by which these things could be implemented, and you'll see there's an appendix which recommends the appropriate mechanisms. I was surprised to learn that probably the best way to do this is by legislative rule. I initially went in thinking that we might do more statutory work, but it's very interesting based on the Constitution giving the legislature the right to look at the rules of proceeding and to establish the rules of proceeding. That combined with the likelihood of the courts to abstain in terms of adjudicating political questions, we thought that it was probably best for the legislature to establish most of this through rules. We do recommend a couple of instances in which statutes be adopted. One would be the privilege mechanism that I explained earlier, and another would be a requirement that lobbyists be required to report to the Oregon Government Ethics Commission whether or not they have engaged in required training. We also recommend that in some instances, a constitutional amendment might be necessary for perfect clarity, given that there is practically no case law, and none in Oregon, and basically not much nationally on the rules of proceeding clause and the punishment clause. So while we are defining what we think those things mean, it is not completely clear, and to be super clear, a constitutional amendment would be necessary. I have one issue to tee up for the group, and that is the one issue where our group remains split at the end of the day, which is the issue of should there be time limitations on making complaints.
So PK, if I can, just before you get into that, just to ask commissioners to pay particular attention to where PK is going here, because I think we have two issues for us this morning, apart from the full report itself. You'll hear her further explanation, and I hope we hear from Commissioner Comstock on the where the committee divided on the issue of time limitation for filing complaints. So the first question for the commission this morning will be, so the work group did not arrive at a conclusion on that point of recommendation. So the first question for the commission is, as a commission, do we want to make that call? Since this is coming out of the full commission now as our product, we have the full authority to make the call, in which case then the report would be amended to reflect not the split in the work group, but it would be amended to reflect the action of the full commission, either one way or the other. So the first question is, does the commission want to make that call? And then the second would be, which way do we go? And so I just ask you to pay particular attention to PK's introduction of this next issue, because it will be something for us to engage in some discussion and possibly a decision when we get to that point.
Thank you. When we presented the draft report to you, we presented these two views as simply two views. In our last meeting, we did determine that there was a majority and a minority view, although it's still pretty close, to be honest. So I'm going to talk about the majority view because, in part, that was my view. And then I've asked Mark Comstock to talk about the minority view, since he very ably served on our group and was in the minority position on this issue. And I want both of these issues to be, fully and fairly represented to you.
And Commissioner, we're on pages 22 and 23 of the report.
Correct. So the majority view was that there should be no time limitation on accepting complaints. And you can see the reasons for that before you, but I'll just walk through them very briefly. I think that, in my view, this comes from my background as a practitioner of employment law. As I mentioned earlier, once an employer is on notice, or actually the holder of a public accommodation is on notice that harassment is occurring in that environment, it is the obligation of that entity to address the harassment. And what we know about harassment is that harassment isn't always just one incident and then it's done. As we've seen through some of the more egregious cases in the public eye, such as the case of Bill Cosby, not all harassment is like that, but there is harassment that occurs sort of repeatedly over time, either with one particular modus operandi or many. And there are cases holding that if an employer knows that this is happening and doesn't address it, then when the next person comes up saying that this has happened, they were already on notice and they are on the hook for the whole thing that happened to persons 2, 3, 4, and 5. So in my view, if the legislature receives a complaint from someone that harassment is occurring and does not respond to it because it falls outside of whatever time limitation is placed, then that puts the legislature on the hook. Now, I have seen instances, particularly in the university setting. Most of my work is representing colleges and universities, many times in Title IX cases, so I see a lot of harassment complaints come forward. I have seen many complaints come forward that are old, some as many as 20 years old. Universities still investigate these things. Does that mean that the investigation is exactly the same as one about harassment that happened 6 months ago? No, of course not. As we know, memories fade, evidence is more difficult to obtain, and so, at least generally speaking, I think those older complaints are much less likely to be found substantiated or to have particular action items that can be done in response to them. Nonetheless, the act of investigating shows that the entity is doing everything that it can do to respond to that. And in some cases, these investigations do reveal patterns of harassment that has taken place over a very long period of time and need to be stopped. So one concern that was brought up, and I'm sure Commissioner Comstock will address this, is what happens to the person who is now accused of something that happened 20 years ago, and isn't it difficult for that person to defend themselves? I think that is true. Yet in my experience, I think investigators are much less likely to find that such a thing has actually occurred because there simply is not the evidence. One thing that we also discussed about the legislative workplace in particular is that, as I mentioned earlier, this is an environment where people's roles are constantly shifting. You might have someone come in as an intern, leave, come back 3 years later as a legislative aide, come back 3 years later as someone more senior. And so folks who have been in a harassing situation oftentimes are in a position where they don't have power, they don't feel like they can speak up, and then they may leave, and you may hear nothing until 5, 10, could be 15 years later, they come back and are in a position where they're working with their harasser again. And then at that point, they feel that they need to say something. The minority view feels that there should be a time limit. My concern is that a time limit doesn't eliminate complaints. It simply eliminates the legislature's available remedies for dealing with the complaints. These complaints are still going to come forward. So placing a time limitation simply binds the hands of the legislature and how they're going to deal with them. I guess the last thing I would say is that in my experience of working with a variety of employers, both public and private, I have never seen a time limitation on an internal harassment policy. And I think that the impetus to have a time limitation here comes because this process may be more formal than most. But I think that that's blurring a line between an employer's internal policy, which governs its internal obligations, and other procedures that we see that are more complex, such as the Bureau of Labor and Industries administrative policy, civil or criminal statutory ways of addressing these problems. So from my view, there should be no time limitation, and I'm going to let Commissioner Comstock raise the minority view.
Mr. Chair. Mr. Chair.
Yeah.
This is Floyd Przonski. I am going to ask for some guidance here. First of all, I want to thank PK and the committee for group for all the work they did. I have now been assigned to be a member of the Joint Committee on the Capital Culture, so I will be taking this subject matter up during the legislative session. I do not feel comfortable at this point voting on this proposal because it's coming before me in my capacity as a senator. And if all due difference, I'm wondering if I could ask to be abstain from voting on this measure, and then if I can be released to go to another conference call meeting dealing with behavioral health.
Let me ask Vicky, how are we doing? Sandy, how are we doing on quorum? Floyd Przonski. Please.
Well, I don't know if any, it depends if any, we had 8 initially. It depends if any commissioners have joined since the beginning of the meeting. Just asking if any commissioners joined on the phone since the beginning of the meeting.
This is Jennifer Williamson. I've joined.
And Jennifer's going to be in the same situation I think I am.
Yeah, I was just going to say, Floyd articulated what I was waiting in the queue to articulate. I'm on the same committee and will be voting in my official capacity.
Well, let me just say that I don't mean to be argumentative, but I mean, I guess I'm not sure, and I will defer to your comfort level, I think, as much as anything. I'm not sure that I see this as strictly a point of conflict we vote on, proposals in the, commission that go forward as bills on a regular basis, in which legislators will be called on to, vote. That's not raised an issue before. But again, so that's just to encourage you to feel okay about it if you want to vote. But by the same token, we don't have any requirement of the commission that we must vote, and we don't have a call of the commission, so we can't make anybody vote. But I guess I would just posit that as a consideration. What I might ask, Representative Williamson, if you're able to stay on anyway, that would give us a quorum to at least complete the consideration of the report.
Oh, I'll absolutely stay on.
Yeah. So the other thing, Lane, I guess, is that I'm more than fine, taking a position if we need to take a position to make certain the report is out so it actually gets to the legislature so we can actually do our work in the session. So, I'm also comfortable doing that, but I thought it was appropriate, and I think Jennifer agrees, for us to raise this concern so we have that on the record before we're asked to do whatever we're going to do.
Okay, then I'm fine with that. I'll defer to your sensibilities about that. As long as Jennifer stays on the call so we retain our quorum, then I'm good with that. So thanks.
All right, just out of curiosity, do we know about how much more time the meeting I'm supposed to be going on to, believe it or not, is supposed to be a 4-hour meeting.
We'll be done
So
by
I'm
then.
not real anxious to jump on it, but I know I'm limited to about 2 hours for them as well.
My guess is we'll be done by 11:30.
Okay, I'm going to go ahead and I think get off because they asked me to be on the very beginning of that call, and maybe I can come back, or if you need me to be back, how about if you just let me know through text through Kevin, and I will get back on the phone.
All right, very good, Floyd.
All right, thank you very much.
And
Bye.
before we
Yep.
move on, I'd like to, this is Krista Obold Eshelman. I'm also on the phone.
Great. Oh, good. Okay, very good. Thanks, Krista.
Mr. Chair, before we move on, this is Steve Bushong. I was on at the very beginning, and then I had to go out and take care of a matter in court. But I'm back on the phone and heard most of PK's report, and I am here for any vote if needed.
Okay, great. Thanks for letting us know. We're in good shape then.
Okay.
Commissioner Comstock, anybody else before we go to the plurality view? Okay, Mark, go ahead.
Thank you, Chair. I want to first comment that PK, or Commissioner Runkles Pearson, did a fantastic job along with Sandy and with Josh Nasby.
Mark, could you get a little closer to your, either your microphone or your, whatever it is, we're having a little trouble hearing you over the jackhammers behind us.
Sorry about that. That controlled the jackhammers.
Okay. Go ahead.
Well, first I want to commend Commissioner PK Runkles Pearson on the report, along with Sandy and Josh Nasby. It is an excellent report. As Justice Landau identified, reasonable minds may differ, and there was a substantial minority, at least in a straw vote, of whether there should be a limitations period on complaints. And this is, I see as a, this environment is different than a standard employment environment. If it were a standard employment environment, we wouldn't have the potential of weaponizing complaints for political means. And that certainly is a substantial and relevant inquiry. And I believe that was the concern of our legislative members. But what we're talking about here is a system that is to be used in the legislature. We only differ on whether there is a need for a limitations period. And that is because of the need to address due process to the respondents. And the example is an example where an allegation or a complaint is made of a time that is quite a ways in the past, and the ability of the respondent to respond and marshal a defense to the allegations that is consistent with due process. I want to point out that the issue of whether the legislature can take some action and consider the complaint of conduct is not limited. Please take a look at page 16, and there are reports, and then there are complaints. And that is, I think, a significant point that needs to be considered, that the legislature can take systematic efforts to address the behavior and the conduct. What we're talking about here is simply a limitation on the limitations period for complaints. The other substantial issue, I think, that this limitations period assists is that it brings finality to the issue, if you will, a complaint. So we have a period where a complaint may be made, and that brings finality to that issue. And it also tends to limit the ability to weaponize the allegations in the legislature. I don't think anyone disagrees that there is the potential of irreparable harm to an accused, and that there are other forums that may be available, and that would be the legal system, certainly. I think that the idea of old allegations coming to the fore would be addressed in the way the legislature deals with the reports. And just as an example, our chair was for many years in the legislature, and if he all of a sudden decided to lobby some items, and someone came forward with an allegation, how that would be potentially a difficult problem, depending on what the allegation is, for a former member to defend. So that is, I believe, kind of the main points of the reason for a limitation. And I think I'll just leave it at that point.
All right, well stated by both sides. I guess I would open the floor for input on first question, whether we should, we can combine this, we don't need to bifurcate this debate, but first of all, the appropriateness, or whether we should take a position in our final recommendation, and if so, which. We certainly don't have to make the call, but it is for us, and we have the ability to do that. And in this conversation, Vicki, if you're still with us and want to participate, having been a member of the work group, I would invite you to share your perspective on this as well, since you heard the full debate and discussion of this. Of course, any vote would ultimately be that of the commission, but I welcome your input if you want to participate. So with that, if anybody wants to speak up, and we'll try and work out traffic on the internet so that we make sure we hear from everybody.
This is Vicki. Lane, Mr. Chair, thank you very much for the opportunity. I was on the minority on this issue, for the record, because I have seen everything weaponized imaginable in the legislative venue, and old-time news has a way of resurfacing. But I think the most important question for you is whether you should opine on that, and I will certainly defer to the commission on that question. That is certainly not my business, and I've said my piece and I'm done. Thank you.
All right. Who else? Anybody?
Mr. Chair,
Judge.
this is Jim Egan for everybody's benefit, and I just wanted to make sure that we have a context for this discussion. So what I'll do is I will move that the commission should take into account and vote on a statute of limitations.
All right, so you want a procedural vote, basically a vote on the procedure first,
Right.
which would then, I guess, we assume there'd be a motion coming forward on one or the other.
Right, and if we get a second,
Okay.
if we get a second on that, then we can have a discussion about whether we should kind of continue on to this vote.
Actually, you're in luck. We operate under Mason's manual, it
Oh, there
doesn't
we go.
require a
Okay,
second.
good.
So the motion is sufficient to put the question before the commission. So the first question is, should we take a position? And I guess so we'll move to a vote on that, but I do want to open it up to a discussion first.
Seeing that my motion made.
Yes.
Honestly, I think that the people of Oregon and the legislature are looking for guidance here. And if they're looking for guidance, we need to give them the guidance that they're asking for. And one of those pieces of that guidance is whether or not a statute of limitations should apply. Without taking any position one way or the other here, I'm just advocating that we should add that piece to the puzzle so that everybody sees we are doing our job, and therefore the legislature is asking a group of people about something that is significant, like a statute of limitations.
Yep, I appreciate that. Somebody else?
Question.
Yes, Justin.
So I assume that we would still be presenting information as is in the final, and we would just be supplementing it with a choice, and all of the perspectives would still be presented to the legislature.
Good question. And I would, let me just say that if we take a position on this, I would work with PK to revise the draft, and I think that's a fair point, because it was such a close call in the work group. My inclination would be to reflect the conversation of the work group in the report, and then indicate that the commission made a call, and this is the commission's call, so that this doesn't get lost. And that's a good point, and I think it'd be a fair way to present it, that there is a recommendation of the commission, but that this particular issue was a thorny one for the work group, and these were the considerations that the work group took into account. That's good. Anybody else? All right, well.
Keith Dubanovich, and
Yeah.
I'd like to weigh in, and I agree with the judge that I think it is appropriate for us to take a position on this. It would be my position that there should be no limitation, simply because we're not addressing the statute of limitations. What we're trying to do is to make a forum that is appropriate for people to express their concerns and their fears, and to have them appropriately aired and dealt with. And unfortunately, memories and fears sometimes result in people being reluctant to come forward. So I wouldn't put any limitation on it.
All right, so anybody else? I think what I'm inclined, I sense that there's probably an emerging consensus of the commission that the commission take a position and make a recommendation on that. So let me ask, is there any objection to the commission moving next to consider the question and taking a position on the issue of time limitation? All right, Hearing no objection, I'll declare Judge Egan's motion to have passed, and so it is before us, I guess, now to entertain a motion. The work group has recommended either 4 years or no limit. I suppose someone could move 8 years or 7.5 years. I'm not recommending that. But I think the question now is for a motion to emerge to see if we have a majority for one or the other.
Mr. Chair, just a point of information,
Yeah.
that the current split is between no limitation
Right.
for at least 4 years.
Oh, okay, at least 4 years. So, okay, thanks for that clarification. So if somebody wanted to move a time limitation, that's a good point then. Okay, so that we're not limited to 4 years. You're right. It says right at the top, page 23, at least 4 years. What is the commission's pleasure?
Well, Mr. Chair, because people aren't jumping in, and I like to.
Yeah, there you go.
I'm going to make a motion that we should adopt the majority view that there should be no limitation. And at the beginning of discussion, I'd like to ask a question of PK.
Sure.
And Mark, if I can do that after the.
The motion is in. Again, no second required, so go ahead.
Thank you. So, PK and Mark, I just need to know this. I want you to assume for a moment, I'm going to say some things that may sound a little politically incorrect, and I apologize, but I'm talking about sexual harassment, so here we go. PK first, and then Mark. Assume for a moment that there's a legislator that's been in the legislature since, let's say, 1985. That creates a long history. And assume for a moment that during the 1980s and early 1990s, this particular legislator, a female, would make references to males and call them honey, sweetheart, and on occasion, sweet cheeks. And maybe there was even some pinching on the cheeks of the face and like. And that now, 3 years later, a complaint is lodged. And it is a complaint of physical and psychological harassment that's 30 years of age. Now, you've said that there are methodologies to prevent the weaponization of complaints. The question, and you've said that there are generational considerations you've taken into account. Assuming that this legislator has cleaned up her act over the course of 35 years, and that sort of conduct is not acceptable at this point, but that it was more, let's not say acceptable, but more acceptable 35 years ago. What's to prevent this complaint from coming to fruition for that legislator to be sanctioned?
Can I ask that?
Please.
Is there a distinction between how it would be handled if it was leaving as a report versus?
Thank you for that.
There's a lot there. I want to make sure I answer all of it. First of all, talking about this stuff is necessarily at times inartful, so don't worry about it. We've got to talk about it.
There you go.
I don't mean that you were inartful. I mean that the discussion can feel that way.
Becky will tell you are correct.
But I think that the conversation is important, and I think that's in part what training would talk about here, that we need to get this stuff out on the table, and we need to talk about it so that we all have a shared understanding of what's correct and what's incorrect. But to your question specifically, I think the method that would prevent the weaponization of this complaint would first of all be that it would have to be made under penalty of perjury, assuming that it came in as a complaint.
Right.
Now, to Justice Duncan's point, there is the potential to make a report which does not request that there be an investigation, right? So I'm assuming now for the rest of this discussion that it did come in the form of a complaint, which would require an investigation. I assume that what might happen in that instance is that an investigator would investigate and first try to determine the facts. Did these things occur? If those things could be substantiated, the investigator would probably say these things are substantiated. In the case of a legislator, the way that this report would work is that the investigator would make the findings of fact, and then those findings would go to the conduct committee. And the conduct committee would look at those and decide whether or not they wanted to, first of all, adopt the findings of fact, and then second, whether or not this was a policy violation. But I think that that your question really gets to what happens after that, because I think there's a difference between finding that there's a policy violation and finding that someone should be expelled from the legislature.
Or that there was a policy violation.
Well, that's an interesting point.
Right.
I think an investigator might say, or a committee in this case might say, Maybe there wasn't a policy at that time. I don't know what the policy was in 1985. But I think that it would be valuable for the investigator to say, had this happened today, this would have been a violation of our policy. But I think the question is what happens after that? You know, is it just the shared understanding of everyone that that is not what the policy allows now? I think it probably would be. And I think that the issue would be how we all receive the training to now know that grabbing someone's face and calling them sweet cheeks is not appropriate workplace behavior. And I think if we're all on that page, we're fine. The purpose of having a policy like this is to ensure that harassment does not happen moving forward. And as long as everyone's on the same page as that, I think we're fine. Now, one thing that we did notice in, not to overly politicize this, but as you all know, the reason that the work group was asked to take on this project is because there was a legislator accused of sexual harassment. And just purely based on the investigator's finding in that case, there was a problem where the legislator was told that behavior was inappropriate, behavior that had been occurring for a very long time, and did not change that behavior. So I think that's a little bit different than this.
As a matter of fact, it is very different than what I have, than the hypothetical that I've given you, because we have a legislator who has come to some sort of realization. So I appreciate that, thanks. Mark, what are you thinking?
Why does this sound like rural argument?
Yeah. I did not defer to you. I did want to respond, Mark. I do apologize.
No, come on, we do not stand on ceremony.
Yeah, well, thank you.
Well, I don't differ much from how PK has described how the process would work. However, there were two examples of conduct, I guess. One is verbal, which may have occurred any number of times, and one is a physical aspect. And I just point out the difficulty of figuring out if something occurred and who might be witnesses of determining whether either of these things occurred 35 years ago. And I certainly believe that the legislature, under the reporting of this, could take action to curb the potential of any repeat of this conduct in the future. And I think that serves the harassment policy as we've proposed it. I just can't see a way of defending the physical or potentially even some of the verbal comments that in your hypothetical 35 years later. And I think that's simply too old and has the potential of weaponizing this complaint process. And that's something that the legislature certainly doesn't need and certainly doesn't need the distraction of it.
Thank you, sure, yeah. Just like oral argument.
Just a brief. I guess what I would say here is that that I agree with Mark that it is difficult to determine whether these things happen. I think that a complaint is going to come forward whether or not you have a formal process to address it. I also think that in most of these cases where I've seen investigators look at very old allegations, most of the time they say these cannot be substantiated, and then they make a pronouncement about whether if that behavior occurred, it would have been acceptable. And I think the process of having the complaint be addressed one way or another, first of all, fulfills the legislature's federal and state employment law statutory obligation to do what they can. But it also provides a valuable learning opportunity for the community to know what the standards of behavior ought to be going forward.
Anybody else on the internet? And Vicki, you're welcome back into the conversation.
And there may actually be a couple other work group members on the phone.
Oh, okay. If we have other work group members on the phone, you're invited to participate in this conversation as well. Anybody? Wow. Okay, then.
Okay, Lane, I just came in. It's Vicki. I can't stand.
Okay. Yeah, good.
There are seated legislators who run on a regular basis. The complaint comes back, the public doesn't understand the process, the public does not understand that it's a 35-year complaint and it was a completely different era. The public only gets the hit piece that says so-and-so was accused of touching somebody inappropriately with a lurid description of it. That is what we mean by weaponization. It happens. It happens all the time in this political environment. We have changed the rules, and I think in fairness, we need some protection for those who are caught in a rule change. That's why I am on the side of a limitation. 4 years seems pretty short, but forever seems too long. That's my point.
Thank you, Representative Berger. Anybody else? I will say, I've not expressed my opinion on this, even privately with PK. My inclination is to favor a limitation, recognizing all of the balances and nuances in this report and recommendation. Granted, a complaint can come forward 35 years later, or 33, or the specifics are hypothetical, under any circumstances. Again, looking at the balance of this, my concern is that a complaint that comes through this policy, we may be more likely to get a complaint because we have a vehicle available to address it. There would be an investigation. It would be a more robust serving of the complaint than 35 years, 33 years. And again, under very difficult circumstances, potential for weaponization and a difficult opportunity to defend on the part of the person accused. I agree 4 years is too short, and depending on how this motion goes, I'm going to support the board recommendation wholeheartedly, no matter how we come down on this. But depending on how this vote on whether to have a limitation or not goes, then I think we would need to consider, if we want a limitation, some discussion on what that period of time should be. But those are my considerations. And just because there wasn't a lot of conversation, I don't want to surprise anybody with the chair's vote, I thought I would at least express that. Anybody else on the internet want to speak? All right, then, Cindy, why don't we do a roll call vote? Just because I think there's one way to capture the votes that are out there online. So if you've got the list, why don't you go ahead? Let's start here in the room.
Oh, what, Mr. Chair, perhaps announce the motion so that everybody knows exactly what we're going
Will do. We'll start here in the room and then go to those online. So the question before the commission now is whether to recommend, the motion was to support a recommendation of no time limit on the filing of a complaint. That would be the recommendation of the commission. Again, going back to Justice Duncan's question, we would then revise the report to show that as the recommendation of the commission, but still reflect the split in the discussion in the work group, so that the legislature would get the full flavor of the issue. So with that, Sandy, why don't you go down the list here and let's see how the vote goes.
So PK Rinkles-Pearson.
Aye.
Judge Egan. Aye. Chair Shetterly.
No.
Justice Duncan.
No.
Okay. Judge Bouchon.
Aye.
Mark Comstock.
No.
Krista Obold-Eshelman.
Aye.
Keith Benovich.
Aye.
John Perry.
Excuse me, did you call me?
Yes.
And can you just repeat? Sorry, I got cut off somehow, and I just got back on the line. Can you just repeat the motion I'm voting on? I know the topic. I just want to make sure.
Sure. The motion was, we have already decided that we will take a position on the question of limitation or no limitation. So the motion is to recommend no time limitation on the filing of a complaint.
Oh, okay. No time limitation at all. So I'm a nay on that.
Okay, nay. Senator Brzezinski, I don't believe is still here. Representative Williamson.
If I can abstain, I'd like to.
You may. That's okay. So what's the count?
Boy, I apologize. was trying to keep track of who's in the room. I apologize.
I have 5 for and 4 against.
Okay,
Let me see.
is that, I thought I had 6-4 and 4 against it. The 4 is clearly prevailed, but we do need some public for this purpose to make sure let's go back one more time, just restate your motion so that Sandy can get
Thank you.
the names associated with the votes, because for public records purposes, or public meetings purposes, we have that. So, PK?
Aye.
Judge?
Aye.
I voted no.
No, so then
And then yeah, go ahead,
yeah,
one
sure.
more time.
And then we're at, Judge Bouchon,
Aye.
Mark Comstock,
No.
Krista Obold Eshelman,
Aye.
Keith Domenovich,
Aye.
Professor Perry,
No.
okay, and Representative Williamson,
Abstain. So what's that, is that 5-4?
That's what I have, yeah.
Okay. In keeping with the work group, that answers that question. The report will recommend no time limitation. Then I guess I would ask, are there any other motions directed at any other particular provisions of the report? Otherwise, I think we are to the point of a motion to adopt the report and recommendation to the legislature as presented by the work group, with the one revision that we would reflect the time limitation as being a recommendation of the commission.
Yeah.
And it probably, I would say, probably appropriately reflect the same kind of split in the commission as we have in the work group.
It's almost identical to
Yeah.
It really is.
All right. So are there any other motions? And if there are no particular motions to elements of the report, I would entertain a motion to adopt the report and move forward the recommendation of the commission. Someone can say so moved. All right.
I'm tired of it.
All right. So the motion before us is to adopt the report as amended by the commission, if I can just make that clear, and move forward with the recommendation of the Oregon Law Commission to the legislature. Any discussion on that motion? If not, we will move to a roll call vote again. And let's go ahead and start in the room here. That seems like the fairest way.
Yep. So PK Ruggles Pearson.
Aye.
Okay. Judge Egan. Aye. Chair Shetterly.
Aye.
Justice Duncan.
Aye.
Judge Bouchon.
Aye.
Mark Comstock.
Aye.
Krista Obold Eshelman.
Aye.
Keith Domenovich.
Aye.
Professor Perry. John Perry.
Aye. Sorry, I was muted. Aye.
No problem. Senator Brzezinski, again, I believe is gone off the call. Representative Williamson.
Aye.
All right. Well, then we have the unanimous recommendation of the report. Just a few words in closing. I'll tell you, when I sat down with Senator Courtney and his staff and Speaker Kotek's staff during the February legislative session and was presented with this as a project for the commission, I blanched, understanding the nature of it, the difficulty, and the time limitation that they already, speaking of time limits, that they already had in mind to have this done by the end of the year. Of course, I said yes, because that's what I was supposed to say under the circumstances, but I really, really had my deep concerns about our ability to meet this, at least with you know, a quality product. I will say that just in the nick of time, the governor appointed Commissioner Ruggles Pearson to the commission with the exact set of experience and skills necessary to chair this, and she said yes when I broached her with the question. Thank you for that, PK. And I think this has been an outstanding process by the commission. I think it's an outstanding product. I want to thank the work group members, those of you on the call, and for the record, every other work group member who spent so many hours during this past 8 months or so. Thanks to Sandy and Josh Nasby as well. I think without that extra bit of staff help, this could not have been done nearly as well as it has been. And PK, again, just a huge expression of thanks and gratitude to you for your bringing this in on time and on budget. I'm proud of it. I have quibble with one part of it, but I have no quibble with the whole of it. And I will be pleased to represent this to the legislature as a product of the commission. My sense is we may not be done with this. I think the legislature will probably be coming back to us now that we have developed this expertise to help with the implementation of some of these pieces, and maybe some of the second helpings with statutory and possibly constitutional amendments and advice on that. So we know that's ahead of us, but I think this is the time to at least take a deep breath and celebrate what we have done, and recognize it as a signal accomplishment of the Law Commission in our long history. So thanks again to everybody for that. Are there any other final wrap-up comments? All right. Well, thanks everybody for joining us today. Appreciate the good discussion, and we will make the final adjustments on the text of the report in the limitations section and move that forward with a letter signed by me and PK to the legislative leadership. And with that, I think we are done. So I will, without objection, adjourn the meeting. Thank you.